Hey, good morning, everyone in Business Law 1. I'm going to do a quick review of Chapter 4. And unlike the promise for Chapter 3, this will be pretty quick, mostly because it's just a fairly straightforward chapter, although it has a lot of important information. Well, most students find this probably to be the driest of almost all the chapters we cover, and we cover quite a few. But it's very, very important. It's administrative law or administrative regulations because government regulates business. We know that at some level. Why do they do that? And I like the book's quote the best. Basically says that in order to eliminate abuses and to control conduct considered to be unreasonable, government has to get involved and create basic ground rules. It's that simple. If we didn't have government regulation and it was just pure capitalistic forces at play, we know that in the long run, the consumers would be injured through monopolization, but also immoral, unethical, and detrimental occurrences would happen in terms of the way in which businesses did their work. We want products to be safe. We want them to be competitive so that the consumer pays reasonable prices for their goods. And we don't want abuses to go on that are deemed to be harmful to society as a whole. And how do we do that? Well, a lot of people think we do it with statutes. We'll have Congress create laws, and we'll have on the state level the state legislature create laws to make sure there's fundamental fair play. And there's a debate about how far should the government be involved in government. A lot of people think it should be small and de minimis, just some basic fundamental ground rules, and others think it should be more intrusive to make sure that the consumer is not only protected from unscrupulous manufacturers, but also from cutthroat competition, such that society as a whole will be harmed. And we balance that through a political process about how far we're going to go one way or the other. But we recognize that the legislature, whether state or federal, just doesn't have the expertise to regulate all the different areas in business that need to be regulated. So what do? I don't want to say they punt, but they do delegate to a certain degree. They can't delegate too much or they'll fundamentally give up their role as legislators. But they have a recognition that certain areas in society need to be governed. And so they create administrative bodies, sometimes called executive. If they're controlled by the executive after they're created, they're executive branch administrative bodies. But they're an extension really of the legislature for the most part. And what it is think about it. The Food and Drug Administration. We as a society recognize that we want food to be wholesome, packaged appropriately, be safe for human consumption, and we want our drugs to be safe for being prescribed or over the counter, and we want them to also be effective. They can't just be phony, snake oil salespeople, right? And so the legislature recognized that, but do we really expect our senators and our members of the House of Representatives to understand how dairy should be processed and how meat should be packaged or how they should be slaughtered, the cleanliness of a slaughterhouse, or the protocols that drugs should go through before it's deemed not only effective but safe for human consumption? No. So they create an administrative body and they put what in it? Well, if it's the Food and Drug Administration, hopefully we put scientists and doctors and things like that in there to create rules that help effectuate our goals. And our goals are to keep society free from harmful drugs, but also to keep drugs effective. They should work. There's all kinds of agencies out there, and that's why the chapter is so important. Agency law, which we call regulations, biggest body of law there is. It's not more important than the Constitution. It's not more important than statutes, but it's bigger, it's broader, it's everywhere. Think about it as a student. You had to sign up, and many of you sought financial aid, or even if you didn't seek financial aid, you wanted to find out about your eligibility, and that's the FAFSA form. And the federal government determines through its regulatory agencies, the student, I forgot what it's called, but the Student Assistance branch of the federal government determines eligibility and how the money will be dispersed and whether or not the colleges are viable to receive federal student aid under their regulations, because they don't want to give it to any mom and pop, academy that opens up because they're really legitimate, and they help guide us through the Board of Higher Education, both on the state and the federal level, of what a 3-credit course will be and whether or not it'll be recognized as college level. All that kind of stuff is based upon not usually statutes, usually regulations. I know, boring as hell, but wicked important. I don't know about in this class, but almost every year I have at least one cosmetologist, I think that's the right word for it, a hairdresser. And I always use that person as an example in the live traditional class, how many regulations they have to deal with. And I used to make fun of a friend of mine who was a barber because he had his barber's license, displayed in the barber shop that I used to get a haircut at. And he said, "You don't know how many regulations we have to go through and how many hours of training and apprenticeship we go before we become a master barber." And I just kind of mock him a little bit. Oh, yeah, I'm sure it's really difficult. And it is. And why is it? Because they deal with certain cleanliness factors, but they also have a skill factor involved as well too. We don't want anybody out there for money, at least, going out and giving haircuts and pedicures and all these different things. They should have some minimal amount of training. And so these administrative rules and regulations are designed to help regulate that area. They're everywhere in the world, though. My sister owned a bar for a period of time, and the most overrated business in the world, by the way. I was a young man. I was in law school when she owned it, actually. And, it's just really awful. But there's all kinds of regulations designed by the Alcohol and Beverage Commission in Massachusetts. It regulates how she has to purchase liquor for the bar and who can work there and all these other rules, how late they can stay open. Regulations really impact your business. Think about my business as an attorney. To determine whether or not I'm eligible to even be an attorney in the state, the Board of Bar Overseers in Massachusetts, in conjunction with an extension of the Supreme Judicial Court, act as a regulatory body to determine eligibility to be an attorney or whether to stay an attorney or what it means to be in good standing. It's everywhere, permeates everything we do. If you have to do anything with the Massachusetts Registry of Motor Vehicles, which I am about to endeavor to do, I'm looking for the bill right now. Apparently I didn't pay my excise tax on one of my vehicles recently, and I can't re-register it. Those are all they often born of statutes, but it's the regulatory body, the Registry of Motor Vehicles, that determines whether or not I can be in compliance with all of their regulations. It's huge. So the different types of agencies, you should know the three types or the three powers. One is the licensing power. You want to become a licensed, dentist, doctor, lawyer, plumber, electrician. All those licenses are controlled by administrative license bodies, and they determine eligibility, things of that nature, and why they exist. Usually, not always, but usually, licensing bodies make sure there's integrity in the arena in which they license. So, in order to be a licensed attorney, you usually have to graduate from law school, and you have to take a bar exam and all of these things, and you have to pay dues and fees and things like that. Same with being a plumber. You have to take so many hours. My father was a plumber, and I was going to become one. And I remember looking at the regulations back in the day about how long I'd have to serve an apprenticeship and under whom I could serve it and all that kind of stuff. So licensing power. Some licenses I used to think didn't have a lot of relationship to skill and integrity and knowledge necessarily, but the great majority of them do. And why do we care? Because in business, if you're not licensed in some industry, not all, but in some industries, if you're not licensed and you try to charge a fee, you do the work and you do it well, and you go to collect the fee and the other person doesn't pay and you sue them, can they raise as a defense that you weren't the licensed practitioner in that area? Yeah, and generally speaking, you cannot sue for a fee in most circumstances. There's a few where the license is designed more as a revenue creating body for the government and not so much a reflection of skills, education, and quality. But lawyers, you can't say you hire somebody really smart. They're going to go to court and advocate for you. They're going to pretend they're a lawyer, for lack of a better way of saying it. They do a great job. They win the case for you. Now they ask for the fee, and you say, "I'm not paying you. You aren't a licensed attorney." Believe it or not, they would win because you failed to have a license, and in order to maintain integrity in the law practice, non-licensed attorneys can't charge a fee. Believe it, real estate. I thought about this before. You get most of your business majors, get some real go-getter who knows how to do stuff on the web and sets up things. I'll sell your house for you for 2%. You don't have to pay those realtors 6%. I'll do it for 2%. They go out and hustle and they do advertising on the web. They find a willing and able buyer, and it sells for what the asking price that the seller wants. Seller's very happy. They acknowledge it's the reason it sold was because of your efforts. Do they owe you the 2%? Well, morally they do. But legally, do they? No, you're not a licensed realtor. You have to be a licensed realtor in order to collect a commission on a real estate transaction. It surprises a lot of people, some of the areas that require license. Some of you, I don't know about this class, I occasionally have some of the early childhood education people, and they're thinking about opening up these early childhood centers, before, I guess, it's preschool really. There are significant regulations to how many kids can be in the place, for lack of a better way of saying it, how many bathrooms have to be there, how many aides have to be in the, you can only have so many students at any given time. I believe the staff have to be certified in certain things like first aid and CPR. I think if they're going to be there for a certain amount of time, you have to provide certain kinds of nutritious meals. And it's all monitored by the government. It's really, really heavily regulated. And a lot of people don't like that. I'm not here to say whether it's good or bad. I'm just saying you've got to be careful about understanding the regulations that impact your industry, whatever it is you want to work in. Rate making power, I'm not going to test you too much in this, but some government quasi-monopolistic entities, the government says, because you're quasi-monopolistic, we have to be involved in setting the rate you can charge. And this is true of the cable industry. It used to be true of the phone industry on some level. Now that they've been broken up and they're no longer quasi-monopolistic, it used to be just one time. Ma Bell used to cover everything, but then it got broken up. It used to be just one company. But now with the airways open through 3G or 5G, whatever we have, it's no longer an issue. Think about trains, for example. Amtrak used to be a big train guy. It sounded weird, but I used to take the train a lot. I loved it. I loved taking a train, like taking Amtrak. But if I don't like Amtrak, did I say, well, I'm going to take a different train? No, there's only one passenger train in the United States. I mean, there's local ones called, like, the Transit Authority Boston, for those local municipal trains. I'm talking about the nationwide trains. Amtrak, there's only one. You can't go on a different train. So because they're quasi-monopolistic, whenever they want to charge a rate from, say, I used to go to Philadelphia a lot from Springfield, Mass, and back, those rates were in part governed by the government. The government would have a meeting each year with Amtrak, and they would advocate that this is how much we need to make to carry our business interests, to be viable, things like that. The electric company is the same way. I don't know if it's any more the case, but for a long time the auto industry in Mass was that way for a long time. The auto insurance industry, I should say, was regulated in terms of the rates they could charge consumers. But now it's been open to open competition. I'm just way off track, but you get the idea that in some areas, the rates by which especially utilities can charge are often partially controlled by the government. It surprises people. And the big one, power over business practices. What you can and cannot do in a certain business might be dictated by an administrative agency. Now, how do they create these rules, these regulations? A lot of people they just do whatever they want. They're like little mini tyrants. Well, there's actually a grand truth to it a little bit. But the legislature creates the power. The executive often gets the power after the legislature creates the body to appoint the administrative leadership. And they have a role to carry out to administer and create rules and regulations in a certain realm. Now, the rules and regulations have to be within the scope of the power that's been given to them by the government. So if their power is to regulate the safe handling of meat, that's their power. They can't go and regulate the safe handling of explosives. They're going beyond the scope of their authority. But when they create a rule, they have to do what's known as notice and comment, and it has to be within the scope of their authority. So they say, hey, we're thinking about this proposed rule. They'll print out the proposed rule. They'll disseminate it to the public, especially to the industry it's going to impact, and they'll allow for notice and comment. Now, what if they put out a proposed rule? I always think about the fishing industry. There's a new rule about how much catch you can get for cod during a certain season in a certain year and how many licenses will be delivered, things like that. And every fisherman person comes to the hearings and protests and says, no, the rule is awful. It's a terrible idea. Can they still create the rule? Yes, as long as it doesn't violate the statute that created the regulatory body. And it doesn't go beyond the scope of their authority. And they went through the process of notice and comment. Doesn't mean they have to comply with it. But the goal, the hope is through notice and comment, if there's enough political fervor to go one way or the other, the legislature might eventually step in. And can the legislature curb an administrative body's power? Yeah, it can trump it. Because remember the hierarchy of law? Constitution's the highest, then statutes, which is legislature, then administrative rules and regulations, then case law. So if an administrative regulation or rule is really screwing you in business, you feel like this is really unfair, I want to fight it. You don't fight it because it's unfair and inappropriate. You fight it politically by trying to get your legislatures to put pressure because they're higher on the administrative agency to change their stance. And if you can't, now you want to sue. But what are you going to sue over? You don't like it? That's not a cause of action. You have to sue because they violated the scope of their authority, or they didn't go through the appropriate administrative procedural steps to create a rule, which is called notice and comment and timelines, things of that nature. It's very difficult to challenge an administrative rule regulation. Saying it's unfair ain't going to cut it. You have to say it violates a statute, which is usually their power, or they didn't follow the appropriate process in creating the rule. Boring as hell. I get you. You should know a little bit about antitrust law. Antitrust law came about in this country when there was a recognition that call them robber barons. I always love that term. In the late, I always want to say the wrong century because it's weird, 19th century, I mean 1800s. That's what I'm talking about. So in the 1900s, when the robber barons, the Vanderbilts and the Gettys and all of the other great Mellons and the steel, I'm thinking about the steel, oil, railroad, all the great industrialists, they were really monopolizing the country. And some of them weren't necessarily evil people, but they were evil in the sense that they make sure they squash competition and that they created an unfair sort of entry into the industries that they controlled. And there was a recognition that that needed to be changed. And they created the Sherman Act. And that's only for federal things that are involved in interstate commerce. What about intrastate that just stay within a state? Well, almost every state has what we call a baby Sherman Act to control unfair business practices within the states. And it basically prohibits any unreasonable restraint of trade. And they use something called the rule of reason approach. Why is that organization doing what they're doing? Is it squelching competition? Is it somehow unfair to the consumer? And if it is, the Sherman Act will be kicked in. Actually, this, not to get too much into history, I know a few of you probably have me for a history class, but the Sherman Act was initially used against the unions because the unions were thought of as inhibiting trade and inhibiting industry. Some people say, well, they were. But the irony of it was when the legislature first created it was to go after businesses, but it was actually going after the workers initially in a big way, and it kind of backfired on the unions. So the antitrust laws. And some things are per se violations. What do I mean per se? I mean, no matter what your intent is, if you do these kinds of things, it's considered to be a violation of free trade or the Sherman Act. And one of them is include price fixing. What that means is when a manufacturer makes a good, say Apple makes a phone, they can say MSRP is $1,000. I mean, manufacturer's suggested retail price, but they can't set the price that the consumer ultimately pays. That has to be done by the retailer. That way competition can stay free. They can sell it to the retailer for whatever they want. Say, hey, we'll sell it to all the different retailers out there that want to sell Apple iPhones. We'll sell them all for $900. But what Walmart and Verizon and all these other stores that carry the Apple product sell them for is up to them. If you control that, the only way you can do it is by having your own outlet stores. Outlet stores can be controlled by the manufacturer because it's their store. But when it comes to other retailers, you can't control. That's called price fixing. It's illegal. Boycotts, that basically says if you don't buy our, if you, things like if you sell me, say I'm Microsoft and you sell me microchips or what, I don't even know what those things are, but you sell me some kind of electronic component to my phones. I'll say, hey, if you want to do business with me, you can make a lot of money, but I don't want you working with Motorola. I don't want you to work with the Google phone thing, whatever that's called. And those kinds of things are unreasonable restraint of trade as a matter of law. Horizontal territory restraints, that's kind of the, if you sell my product, you can't sell competitors' products. I'm sure there's a lot of secret deals like that. One of my favorite secret deals that happened a long time ago, just as an interesting little story. I'm not a coupon guy. There's a whole TV show on coupons. I tried to be a coupon guy at one time. I'd cut them out every Sunday when I used to get the Sunday newspaper. And I'm going to get real frugal, and I'd go to the store that have double coupons, and I'd be smart, and then I would never use them. They'd just build up, and by the time I go decide to use them, they'd all be expired. But there's a whole culture of people that like to use coupons. And when I was a kid, I can remember there was a coupon war in Massachusetts. When I was a kid, I was like a teenager. I was actually working at one of the supermarkets. There was a time where there were some supermarkets giving what we call double and triple coupons. So if you had a 25-cent coupon, some stores will say, well, we'll double it. Now it's 50%, or we'll triple it, 75%. Well, guess who gets hurt on that? The supermarkets. They're kind of in competition with them. Well, that competition is legal. But what wasn't legal is many of the supermarket CEOs, big shots at the running of these corporations, got together and says, hey, we're losing all this profit by doing these double and triple coupons. If we all agree just to honor the manufacturer's coupons as they are and not double or triple, we'll all make more profits as long as we can all agree to do it. And they did. And what was that considered? A violation of the Sherman Act, which it should be. It's kind of like if all the automakers got together and say, hey, we're getting killed by giving all these great discounts on the president. Let's not do that anymore. Let's all charge a minimum basis. And if we agree, it'll be good for everyone's business. That's illegal. It's kind of criminal almost. It probably is criminal. There are some sections of the Sherman Act that are criminal. Price discrimination, things like that. Those are automatically unfair competition. Walmart, many years ago, got sued by, I think it was called KB Toy. And I think it was over the Hot Wheels car, Matchbox, I'm not sure which. They supposedly sold them at a price where they made no profit. And KB Toy says when you're selling toys at no profit, you're clearly doing it trying to kill competition. Therefore, it's a violation of the Sherman Act. I believe Walmart won that case, and they argued that we don't charge cost for Matchbox, whatever the toys were at the time, to hurt competition. We do it to drive up sales. Well, if you're not making any money, what does it matter if you drive up sales? No, we're not driving up sales on the Matchbox. We keep the Matchbox and toys way in the back of the other corner of the store. So in order to get over there, to get this deal where we make no money on, you pass by the Tide detergent, you pass by the toilet paper section, you pass by the homeware is good and the fishing tackle and all these other things, and consumers will generally pick up another couple of things where there is a profit margin in there. That's a reasonable business practice, and they survive that. And those are the kinds of questions that come up all the time. But think if I'm Standard Oil, I'm Rockefeller, and I'm Standard Oil, and if some competition comes in and they're going to charge $3 a gallon, and I know for a period of time I could survive, it will hurt me for a little while, I'll charge $1 a gallon. So everyone's going to go to Rockefeller's gas station. The consumers are. And what's it going to do to the competition? Well, if it costs them $2 to produce the gallon of gas, they can't afford to sell it for $1. They'll go under much quicker, and that's what monopolies used to do. Environmental protection, there is a test question on that. I'll just leave with this under the comprehensive environmental CERCLA, Comprehensive Environmental Response Compensation Liability Act. Who's responsible for toxic waterways and land that have environmental hazards on them? The owner is, the polluter and transporters of the product are. So this is why it's very, very important. It's strict liability. So say, and I am a green guy, and this almost happened to me. I don't know why. I tend to want to do a million different things in my life career-wise, but maybe about 10 years ago, I was looking into actually buying a gas station with a couple of friends, and it had a hardware store and a coffee shop. I don't know what we were thinking. And because I know a little bit about this stuff, the first thing I asked about was in the gas station was, has there been what we call a 21E assessment, meaning have the soils been tested to make sure there's no contamination from these gas tanks that are on your property? It's been a gas station for a long, long time. I said, oh, great news. I had that done last year. And usually when someone says great news, I thought the test came out great. Great news they were done because it costs a lot of money to run these tests. The bad news was there was petroleum in the soils, and they were under an order to clean them out, meaning not only take out the current tanks that were in the ground, but remove the soils that were contaminated. It has to go to a special place for processing. And then new clean soils have to be taken in, and all kinds of test holes have to be dug all the time to make sure there isn't more leaching beyond it. It's a huge nightmare. So you in business, if you're thinking about buying an old business that was once a manufacturer of goods that used a lot of chemicals and things like that, if you're going to get a mortgage, the bank is going to require you to do a 21E assessment. They're going to look at the history of the land or the building or the series of buildings that you might be purchasing, and they're going to say, we're concerned there might be asbestos or contaminations in the soil or heavy metals or things like that. And why does the bank care? Because if you don't pay your mortgage, the bank's going to foreclose, and guess who owns the property now? The bank. Are they liable for cleaning it up? Yeah, anybody that owns it. even the clean person. So even the honest non-polluter is going to be liable. So I wouldn't buy that gas station. I was so fearful of the cost of it. In fact, that gas station still exists not too far from me. They no longer sell gas. They removed the tanks, but they couldn't afford the cost of, I guess, putting new tanks in. And so now they're just basically a convenience store and a utility hardware store. And they got to be suffering big time because the gas station used to bring the people in. You don't make a ton of money from gas. I don't know why I'm talking this. But anyways, the point is even if you're buying with cash, you're not taking a mortgage. The bank is definitely going to make you do this assessment because you don't want to buy a liability. And the second is, if you're buying with cash, you still want to do the 21E assessment. It's called a 21E assessment. Just basically, you want to have an assessment of the property to make sure you're not buying polluted land because you don't want to be responsible, because you will be by law, just as an owner, just even if you didn't do it, you're going to be responsible for the cleanup and the mitigation services. That can cost a fortune. I'll leave you with this last thought when it comes to this whole concept of liability cleanup. There is something called brownfield legislation in Massachusetts. It's a good law. I just want to mention it real quick. Sometimes you can work with the government saying, these old factories are sitting vacant. There's some issues with cleanup, and I believe this is with the casino in Everett. They put their site on a place where there was some dirty soils and some issues like that, and they work with the government saying, why just leave it dirty and this, that? If you work with us and help us clean up the property and hold us to only an accountability of a certain share of the percentage of cost, we'll work with the government, we'll buy the land, we'll turn it into useful, I don't know how useful a casino is, but you get my point. They'll redevelop the property with the understanding there'll be limited liability for the toxins and things that do have to get cleaned up, and the government will help supplement that. I believe it's under the brownfield legislation. Anyways, chapter 4, dry as hell, boring as hell, but really important because administrative bodies can do what? Control who can work in a certain industry, licensing, and certain quasi-monopolistic, especially utility type organizations that suffer from competition. They may actually set the rate of return or the charges that those organizations can demand from consumers. But lastly, the big one is they control how businesses have to behave, what they can and cannot do. And that is huge. And they have a lot of power granted to them by the legislature. So we'll leave it at that. Dry chapter. Thought I could do it in 15. Did it in 30. Be well.